Oh, we're back. All right. Hello. So the weird thing about that is that on my end, it was telling me that we were back and I was answering questions as they came in chat. So I think some people are going to have answers like in the upload that they didn't see, but we'll see what we can do. It is, listen, live streaming is always kind of confusing. YouTube is working hard on it, I know, but what can you do? So Leah, I answered this in the other one, but I fear that it didn't get to you, so I'm going to answer this question right now. So I'll read your question. Leah Brown says, disability discrimination case. If the damages are mostly of an emotional nature, is it worth bringing the case? The answer to that question is going to be detail driven, but I'll give you the kind of the metrics to look at. So, and also like, listen, break it up. Like there's a question about whether or not it's worth it to you, the plaintiff. That's one thing. There's a second question, and I can't answer that because I'm not you, right? But the second part of that is it worth it to law firms? And I can answer that. Although I will say different law firms have different margins and, different situations. So if you have emotional damages and you have really egregious story for your disability discrimination case, right? Like I'll get like, hey, you effing cripple, blah, 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 blah. Like that's a pretty egregious story, right? Horrible thing to say, right? And let's tie that you have good treatment. You have mental health professionals treating you so you can beat the soft caps and your emotional damages. And you have physical symptoms of anxiety or trauma, like physical symptoms of your emotional trauma, right? Like that's going to add a lot of value. In that scenario, it would absolutely be worth it for a law firm to still bring that emotionally damages driven case. Now, I kind of mentioned different law firms have different break-even points, different margins, right? So there are small firms out there where all they have to do is win you like 20 grand and they make money. Now, they're then investing less in your case. But what's worth it for them is different than what's worth it for us. Like we spend pretty heavily on a case. Generally speaking, we need to make somebody north of $40,000 to even hope to break even. Even hope, right? So like it's going to be firm driven as well in terms of what's worth it for the firm. Sage Page asks us, my job is trying to promote me in the middle of a lawsuit. What should I do? Listen, take it. If you want the promotion, take it. They might in part be trying to look good. They might also just be careful to not retaliate against you. But if you refuse it, they're still going to say like, oh, we tried to promote Sage Page. So, it's not our fault Sage Page didn't take it. So I would say probably just go ahead and take it. Excuse me. Also talk it over with your attorney, right? I mean, listen, I'm just one guy on the internet. All right. Do we have more questions? Yes, it is working, John Doe. Thank you for joining again. Aaliyah Brow says, I was told my employer only cares if a case will damage the reputation, which makes me concerned they won't do anything unless it is about to go to trial. Aaliyah, so there's two different kinds of employers. There's employers who only care about reputation, and there's employers who care about the potential damages in the case. In all honesty, most employers care about both of those things. I don't think it's true that any given employer only cares about reputation. So I would say don't be scared away. That's something they're probably doing to try to scare you away. GB says, I submitted a complaint on July 13th of 2023 with the DHR. So that I believe that is the New York State Division of Human Rights for discrimination acts that occurred 7/14/22 and 11/05/22. Okay. So the attorney submitted a response that my claims are time barred. So you have 365 days to get filed. That does not sound like it's time barred to me. Sounds like you filed in 364 days. So that sounds timely. Julio, I also answered this question in the other stream, but I don't think you were getting it, so I'll answer it again. Julio says, my mediation is coming up on March of 2023. Are things sitting still on the EEOC side until this date? What could be going on in the background? Julio, they're going to let it sit in ADR, in alternate dispute resolution, until the mediation comes up. And then if the mediation fails, they're going to move it to enforcement. Things are not standing entirely still, but they're, for all intents and purposes, kind of sitting still. So yeah, you're waiting to see if your case settles right now. GB, you would quote the New York State Human Rights Law statute of limitations to them, and then count the days and say, look, see how the days are within the statute of limitations, which sounds like I'm being rude and pedantic, but like, that's what you need to be rude and pedantic to this jackass who doesn't know the statute of limitations. Not being rude and pedantic to you. I'm just telling you to maybe be like, it's weird. You passed the bar, but you can't count the fucking days, loser. Like, obviously be polite. Don't be like Vince, but okay. Nina 2003. I also already answered this question. I'm re-answering a lot of questions here. Which I think those other questions are going to be included on the download, like the upload of that live stream, but I don't know that for a fact, so I'm just going to answer this again. So Nina 2003 says, how can a lawsuit for unpaid wages impact a race discrimination lawsuit against the same employer? Nina 2003, depending on some specific circumstances, it could draw from the same pool of damages. So if you win the unpaid wages, it might reduce the economic component of your racial discrimination case. Jupiter James said, which is a sick name, Jupiter James, love it. What's the process, time, and timing for discovery to happen, and when are you to be paid? Well, I don't know what you're getting paid for, but I assume you have either a workplace discrimination case or workplace sexual harassment case if you're on our live stream. So discovery is going to happen if you're in court as per the discovery order. So there's going to be a scheduling order. If you're in federal court, they're going to tell you, hey, these are discovery deadlines. This is when you turn over X. This is when you turn over Y. This is when depositions happen. All this has to be done by X date. And like, that is your timeline. Now, if you're asking me, when are you going to get paid from this case? Probably about 30 days after you settle, or if you go to trial some point after that, if you win. Julio says, another employee has also filed an EEOC case within the same office. Should my mediator know this? Yeah, why not? I think that could be helpful to your mediator. The EEOC has taken this additional case as well. Yeah, listen, I think multiple cases are always going to help. You should probably reach out to that employee. You can corroborate each other. You can cooperate. It could have real value. All right, let's keep going. Do we have more questions? Please remember to like the live stream. It really knocks us down when they kick us out. Like, I don't know what YouTube was doing. It like shut down the live stream and then I had to reload. Any more questions? More questions. All right, if I don't have any questions, I'm going to tell you the worst thing that happened to me today. I went to the butcher and I had a $600 butcher bill. Farm's going to be full for the holidays. But yeah, damn, that's a lot of money. Betty Lynn is saying, my potential attorney is far away. It needs to take a plane to court. Should I pay? Betty Lynn, only if they're incredible, right? I mean, that's kind of our model too. So Betty, we will take cases all over the country in federal court, EEOC, and I fly teams of attorneys out. And I always tell people they should talk to local counsel first, because the local counsel is good, then they shouldn't hire us, right? So if you're saying like, listen, this attorney is the sun, the moon, the stars, this attorney is incredible, maybe they're worth it. I don't know, but check your local options first, because your local options are going to be way cheaper than a law firm that has to fly people around the country, right? And that's why I always say, like, listen, if you're in like North Dakota and there's not a plaintiff side employment attorney to be found, yeah, firms that fly attorneys around the country, national firms, are going to be worth it, including my own. But if you're in like Chicago and you got lots of good options for counsel, including attorneys like Attorney Castillo, then I would say to you, no, don't hire my firm, right? Like that, you should go with the better deal. That's just my take on that. T-Rex, no, it's a Talisker Storm. T-Rex, are you the person who sent me that Woodford Reserve? If you are, thank you very much. Please don't all send me gifts, but someone was very kind and sent me a number of bottles of very fine liquor, and I thought that was really delightful of them. But please don't send me gifts. GB says, I filed for unemployment because my employer didn't want to provide a reasonable accommodation to allow me to do my job. The employer did not contest it. Can that be used as evidence? Probably not. They just didn't want to fight you on unemployment. Michelle Tarleton says, hi, Vince. Current lawyers, they have filed with the court. I have a right to sue. Should I be receiving copies of the items without requesting them? So your file with your attorneys is your property. If you have a question about the firm's abilities or capabilities to maintain your records, then yeah, you should be like, listen, I need to get a copy of everything all the time. But generally speaking, I don't think most firms would send you copies of everything. RCCC, hello, it's good to see you. RCCC says, how much do former coworkers typically know about a settlement if the case only reached the EEOC level? Very little. Shockingly little. Like, I would say almost nothing. It is in the employer's interest to keep things quiet. Excuse me. And in most jurisdictions, they're able to purchase that silence, that confidentiality from the plaintiff. So generally, coworkers know very, very little about the settlement. GB, thank you for saying this channel is awesome. That's very kind of you. Michelle Tarleton says, how long after the conformed copy received of the right to sue letter, I presume, does my attorney have to serve the company with the official complaint? 90 days. Well, no, that's not true. So your employer has 90 days to get filed in federal court. Once you get filed in federal court, you have additional time, depending upon the local rules of the federal court, to serve your lawsuit. And generally speaking, you would probably do waivers of service first, and then if waivers of service for some reason failed, you would engage in process service. Marcus Anderson says, just be a judge that flies all over. You do a great job and stop employers from all this wrongdoing. So Marcus, I actually do sit as an arbitrator. I'm an employment arbitrator. I hear cases as an arbitrator, which is like a judge that has not been elected, essentially. Like, it's often in a lot of employment agreements, you'll see language about arbitration. And in that, generally speaking, I think 8 times out of 10, you're going to see something called the American Arbitration Association will be the arbitrator hearing your case. That will often be me. So yes, I agree with you. I think I'm swell at it. Michelle, I'm really glad this was helpful. I hope good things for you. Betty Lynn asks us, my employer is extremely picky for approving disability leave benefits. They only approved up to the next doctor visit. Is this because my attorney already got the right to sue letter? Is the employer trying to deny to avoid disability termination? I don't know. I suspect if they're approving it up to the next doctor's visit, the answer's probably got more to do with what your doctor's writing. Like, if your doctor was like, hey, this accommodation has to go on for 3 months, they would probably, if they're in litigation, approve it for 3 months. but your doctor might not be specifying. And so they're just saying, well, we need to hear more. We don't know how long, so we'll just go to the next doctor visit, is my best guess. Noriega, one of the last ones, says, why would a plaintiff counsel turn down an initial early mediation? Noriega, generally, I think that's a bad idea to turn down mediation. I would say if somebody wants to talk about giving a client money, as attorneys, we should be there. Now, by the same token, if defense counsel's like, hey, you want to go to mediation, but like you got to get your client to take 20 grand or it's not going anywhere. At that point, I might go to my client and be like, yo, I don't think you should take 20 grand. Do you want to take 20 grand? And the client's like, not a chance in hell I'm taking 20 grand. I go back to defense counsel and say, so you want to do mediation. Well, I want to tell you up front, we're not taking 20 grand. So like, you better come with more authority. And then defense counsel might be like, okay, yeah, that's fine. I'll get more authority, but you pay for the mediation. No, that's not going to happen. That's not a thing. You pay for the mediation. You're already fucking around. Like I'll put attorneys in seats and we'll sit and listen about you giving my client money, but I'm not paying for that mediation. You're fucking around. What do we have? Oh, Jupiter James, we have a question. I was somewhat forced into arbitration due to a sneaky contract. Nevertheless, we are now in the stage of naming names and have found an arbitrator. Is this a good sign? Yeah, it can be a good sign. I mean, arbitration can be an incredibly fast and useful process. I personally am opposed to mandatory arbitration. I have kind of a policy of not accepting mandatory arbitration. I think arbitration is fantastic for folks who want it, right? Like if they're like, I need a more sophisticated, I'm not saying judges are stupid. I'm certainly not saying judges or juries are stupid, but like you can get a subject matter expert arbitrator. Like if you're, I'm trying to think, I used to work at an investment bank, right? So you need an arbitrator who does employment law, who knows about the world of investment banking. You might be like, that's the guy. Give me Vince, right? And I can come in and I can understand the industry because I used to work in that industry, right? So that's useful. That's much better than your average judge. Your average judge does not have private equity experience, right? Like it's just not a thing. So I think arbitration can be incredible. It can be fast. It can be efficient. It can be private, right? It can be that the arbitrator knows more about your industry. There's lots of things that can be great about it. Also, though, listen, sometimes you want a jury and you want a public matter. So it's different. Jupiter James says, I wish you were our arbitrator. I do too, buddy. I make quite a bit. I make, I think $11.60 an hour to sit and arbitrate. So by all means, although now we've had this interaction, I cannot be your arbitrator. I would not. I also have to be fair as an arbitrator, right? Like I have to really, like I can't let a bias one way or the other. Because people are going to be like, "Oh, Vince is always going to find for the employee." No, I got to do the job real. I got to find what I think is right. So I'm straight down the middle. Yeah, Marcus, I hear you. Listen, there's definitely arbitrators who do not award as much as juries. But also a lot of the jury verdicts you hear about don't get collected. Like a lot of them don't conform with the way damages are calculated. So they'd be like, oh, we're giving this plaintiff $30 million. And like every employment attorney, like reporters will call me and be like, what do you think about the $30 million verdict? And I'm like, it's not real. That person's not going to get that money. That's not a thing. They're like, no, it's real. The jury did it. And I'm like, yeah, but it's going to be appealed. That person's not getting that money. That's not a thing. So yeah, Marcus, I generally agree with you. Juries do tend to get a little bit spendier, a little more generous with the verdicts, but by the same token, a lot of those don't get collected. John Doe says, do state laws prohibit NTAs for settling discrimination harassment cases help or hurt plaintiffs? Doesn't mean an employer is more likely to drag it out to a full-blown trial. So John Doe, I've actually had this specific debate with a relatively famous actress repeatedly. That's not true. Famous actress. So my issue with state laws that prohibit NDAs in settlement agreements is that it strips plaintiffs of the ability to sell their silence. And this is a very complex, I think I've done videos on this, but it's a very complex, like A case will settle for much more than it's worth in certain situations where the employer wants to purchase silence. Like, I have routinely settled cases 3x, 4x, 5x, what the case is actually worth, because the employer calls me up. I don't even know how they did. I had a gentleman call me up on a Saturday on my cell. He didn't have my cell number. I don't know where the F he got it. And he was like, how many zeros? And I'm like, who is this? Right? He's like, got your letter. I have a tendency to do demand letters Friday evening after everybody's left for the office, so they can't get representation. You get some wild responses. So anyways, this guy calls me Saturday morning on my cell. How many zeros? And his whole concern was the NDA. By the same token, I've noticed that Apple computers in California right now, where they can't really, because of that law, demand confidentiality in settlement agreements, they don't give a fuck about cases right now. They're like, yeah, we're not settling. Litigate. We can't buy silence, so what do we care? That is brutal on plaintiffs. So I think the thing that I'm really trying to get at is that these state laws that outlaw plaintiffs entering into NDAs and these settlement agreements, they're really good for society, right? So those laws get the stories out, and the stories can change hearts and minds, and that's incredibly valuable. That matters a lot. However, we're doing something very good for society, and we're being very utilitarian about it in terms of utilitarian philosophy of the good, because we're putting the benefit of the many over what's good for the few, the plaintiffs, right? So if you're a plaintiff and you're like, oh, I got a case worth 150K, and but I'd like to settle it for 500. Well, that can happen in certain situations if the employer would like to purchase your silence. That does happen. But if you're in California, you're like, I got a case worth 150K, but I'd like to sell it for 500. That employer is going to say, I would like to invite you to go fuck yourself. That's not going to happen. That will never happen because you can't sell your silence. In this state right now, we have not yet figured out how to do that. So no, right? So like that, like you can't say that plaintiff wasn't harmed. You can't say it. Like that plaintiff was harmed. No question. And I've had this debate repeatedly. And it's hard. It's very hard to debate with actors with because they're very persuasive. Because they're really good at emoting, right? I've had this debate repeatedly. Okay, Carol Mosier says, what's the difference between a civil rights attorney and an employment attorney? Which one is best for workplace discrimination? So employment attorneys handle workplace discrimination. Civil rights attorneys handle discrimination in all other areas of life. Like if you're experiencing discrimination at the hands of the government, particularly. So if you're experiencing workplace discrimination, workplace sexual harassment, you want an employment attorney. There are civil rights attorneys who do both. There are employment attorneys who do both. But honestly, both fields are pretty in depth. Like you really got to commit, in my opinion. RCCC says, is it common to request that the perpetrators take sensitivity or EEOC training as part of a settlement agreement? What form do these trainings usually take? Do employers have to pay for them? It is a common request. Yes. The trainings take a variety of different forms. Different companies offer them, and the employers do pay for them. Generally speaking, this is something that clients seem to want a lot. And here's the vibe. So the employers are like, no, or we don't care. But whatever we have to spend on this, we're going to take out of the settlement for you. And a lot of my clients will be like, well, no, I just want the cash. But some clients, and somebody contacted me recently, they arranged training for the entire company because of their case. And that was amazing. But it's hard to come by. And the trainings are limited value, in my opinion. A lot of them are just videos. Daniel Monahan says, what are your thoughts on the EEOC process for federal employees? Grueling. It's grueling, expensive if you hire counsel. It's a little stacked against you. Is it worth pursuing though? Yes. Or would it be better to go straight to federal court? That's tough. That's a tough answer. Detail-driven answer. I need to know the situation. TVid asks, how do I find lawyers that have previously sued my employer for discrimination? Is there one directory? There is a directory. It's called Pacer. Ooh, wait, my chat just jumped. There's a directory. It's called Pacer. So you would go on like the federal docket and you would look for cases against your employer. You could also check your state docket, potentially. Viral setting zombie is taking issue with my arbitration hourly rate. Correct. It's $1,160 per hour. That's generally paid by the employer. I don't know why you're mad about it. Or if you're mad. I guess maybe you're not mad about it. I don't know. When you upload a new... Oh, so Julio asked, when you upload a new doc for your EEOC portal, do you know if the person overseeing your case gets a notification? I don't. Never been on the back end of the EEOC. I could probably ask somebody for you. I would imagine they do. I assume they do. After the holidays, if you remind me, I can make some calls for you. Michelle Tarleton says, my attorney said it's too early to give my case a valuation. The case is filed with the courts and about to serve my company, but they won't put a dollar amount on the... So, Michelle, they might be saying that your damages are growing every day, but if you're filing a case, like, I would assume you've already made a settlement demand. I don't know why you wouldn't already have like a working rough valuation at this stage. I have questions, but again, like, I'm just a guy on the internet. Like, if you have counsel that you trust, don't call them up and be like, the second biggest employment attorney on YouTube says you're doing it wrong. Like, they will not appreciate that, and they will get mad at you. So listen, I don't fully understand what they're doing there. Like, I would do a valuation at the time that we were going to make a demand. Certainly that's how our firm does it. But yeah, I don't really understand why that would be. Carol, I'm gonna skip your questions. I don't fully understand. I guess Carol, if you can link me to the content where someone is saying that the burden of evidence shifts back to the plaintiff, I will consume that content for you and try to make you a standalone video. But I don't understand what you're asking in this context. Okay. GB, I've got your question here. So GB says, can you discuss the futility doctrine, which states that a person with a disability does not have to engage in a futile gesture where the person has noticed that the company does not intend to comply with the law? GB, I can give you an example from my own cases. So I had a case against Verizon where Verizon held a meeting with like 200 people. And they said flat out, there are no accommodations, there are no light duty, that's not available. So my client did not ask for an accommodation because my client needed light duty. And we sued. And Verizon was like, you never gave us a chance. Why didn't you give us a chance? We would have accommodated. We would have done a thing. Yeah, come on. It's like, oh, well, what did you do? Because we have this recording of you screaming at 200 of your talented employees, telling them there's no light duty and no accommodations available, right? That's, in a nutshell, the story of that gig. That doctrine. Like, if there's no point in asking for the accommodation, you can probably get away with not asking for it. In an ideal world, do you still ask for it? You do, because that simplifies your litigation, but like, you might not have to. Morale Setting Zombie says, can non-attorneys get mediation jobs? Yes. But I don't think you're asking actually about mediation jobs. Mediation is like trying to settle cases. I don't sit as a mediator. I sit as an arbitrator. I'm not saying, let's all get along and settle the case. I'm saying, I've decided this case. Here's what's going to happen. That is a different job. Can a non-attorney do that? I don't think so, but I'm not up on the laws. It'd be hard to get work. as a non-attorney. Like, how are you going to sit as an arbitrator when you don't understand the laws? But maybe. May HM says the EEOC redacted parts of their investigative file I obtained through FOIA. Why would they do this other than for reasons to protect? May HM says the EEOC redacted parts of their investigative file I obtained through FOIA. Why would they do this